Breaking news coming in, viewers. The Supreme Court of India has delivered its opinion advisory on whether the Supreme Court can impose timelines on the President of the country and state governors for acting on bills passed by the state legislature. Now, the 5-judge bench has cleared that a deadline cannot be set. No timelines can be given to the President or state governors. However, the Supreme Court added that the governor cannot indefinitely withhold a bill for consideration. The bench also said that the apex court cannot use its special power under Article 142 to declare bills pending with the governor as passed on its own. Citing the Constitution, the bench, in a unanimous opinion, stated that under Article 200 of the Constitution, decisions of the governor and under Article 201, decisions of the President can be judicially reviewed. That is, the court can intervene, but that can only happen if the bill becomes law. All right, this is an opinion advisory, and to get a better understanding of what it means, I'll now cut across to our correspondent, Dharamjot. Dharamjot, of course, this is legal language. If you can break it down for us, what this really means.
Well, Shivan, first up, it's important to understand the context in which this particular advisory has been put out. Now, just to explain this better to our viewers, on the 8th of April this year, the Supreme Court had issued a ruling with respect to a case pertaining to Tamil Nadu. And in that ruling, it had said that the Tamil Nadu governor had acted illegally by delaying assent to 10 bills of the state legislature. Now, in that verdict in April, there were two major takeaways that also became a point of contention. The first one was timeline of assent or approval. That ruling in April had said that there is a clear timeline mandate. The Supreme Court in its verdict then had given governors a 3-month period to act on the bills. The second was that it limited the powers of the governor. In the April verdict, the court had said that the governor does not have what it called unbridled discretion to withhold assent, and that it must act on the advice of the state's chief minister and council of ministers, basically establishing cooperation that is required between the governor and the state administration. Now, following that verdict in April is when this entire conversation started, and then there was a grant put for presidential reference in the Supreme Court. Now, that is where this particular advisory and opinion comes in, which is why the Supreme Court 5-judge bench has now clarified that there cannot be a deadline set for the governor and for the president to decide on a bill. Now, this is an advisory in response to the 3-month deadline that was set in April in the Tamil Nadu case. But the court today has also said that the governor cannot indefinitely withhold a bill for consideration. Now, quickly, why was this a point of contention? This was a point of contention because the union government had said that there are 4 parts of this constitutional law that gives powers with respect to bills. It said 1 is to assent, 2 is to not assent and return the bill, 3 is reference to president. It also says that there's a 4th power that the governor or the president has, and that is to withhold the bill. But the opposition says that withholding is not given in the Constitution. There are only 3 parts to it, either to assent, to not assent, or give reference of the bill to the president. It is with regards to this particular contention that the 5-judge bench has now given this particular advisory. However, it's important to note that this advisory does not really it's not legally binding on the Tamil Nadu case. It does not have a legal impact on the verdict of the case that was delivered in April. It is simply an advisory that establishes clarification and gives more details and more clarity and more locus standi to what the Constitution says about a particular act or powers of a certain authority, Shivan.
Dharamjot, thanks so much for breaking that down for all our viewers. And of course, as of now, as Dharam mentioned correctly, that this is an opinion advisory which has been given, but it only adds more locus standi. As of now, no timelines can be given to the governor or the president, but yes, they cannot sit on any kind of bill indefinitely. That's where the Supreme Court has given their opinion as far as the 5-judge bench is concerned. That was Dharamjot Kaur getting us the latest from Delhi.